Good morning, Your Honors. May it please the
Good
Court.
morning.
Garrett Frago for the Commonwealth. With me is ADA Stephen Gagney, and also with me is ADA Rachel Eisenhower. Your Honors, we're here on the Commonwealth's interlocutory appeal on a motion to suppress that was allowed by Judge Rufo in the motion court. The Commonwealth submits that Judge Rufo made two major errors in his decision, and I suggest when the first error is overcome, the rest fall like dominoes. In this case, Your Honor, the defendant was operating a motor vehicle on Route 140 on June 9, 2006, at a time when a state police trooper was also on duty. The vehicle operated by the defendant ran out of gas and became disabled and pulled into the breakdown lane. The state trooper pulled behind the disabled vehicle in a community caretaking function to assist the defendant. The defendant came up to him, said, "I'm out of gas, what should I do?" There was some conversation about getting a tow truck to assist him. Nonetheless, the trooper and the defendant remained on scene. There was some conversation. One thing led to another in which the defendant's license and registration were run. And after some further conversation, the trooper asked the motorist...
Well, let me interrupt you. So his license and registration were checked. The officer found out that he did have a license and the car was properly registered.
Correct.
End of story.
End of story, isn't it?
Your Honor, I would say if there was an actual motor vehicle stop. I submit this is not a motor vehicle stop because the trooper did nothing to command the defendant's car to come to the side of the road. The defendant's car ran out of gas.
Once the officer was able to determine that this was a lawfully licensed and driver and registered car, what purpose did the officer have to stay beyond that point?
Oh, I think there was a very serious public safety issue for the trooper to stay. There was testimony before...
Okay, he could have stayed for public safety, but he couldn't. What right did he have to ask any more questions?
Why wouldn't the officer be permitted to have further conversation with the defendant? We're not in a situation where
Why
he's
wouldn't the
detained.
officer just say, okay, you're stuck here by the side of the road. Some arrangement had been made to get the gas to the car, correct?
Yes.
Yes. So I'm going to sit in my cruiser right behind you with my lights on until, who was it, the girlfriend or somebody was going to come with
There's another vehicle that showed
another
up.
vehicle was coming with the gas. Why didn't he do that? He shouldn't have stayed around saying, well, you know, let's talk about this and talk about that, and then finally,
Do you mind if I have a dog come sniff?
if I have a dog come sniff this?
Well, the trooper could have done that, but there was nothing prohibiting him from having further conversation with the defendant. The defendant was not detained. He was not in custody in any situation that was different from the police officer talking to a citizen on the street. And I suggest that's the analysis that the court would have to undertake. This is a situation where the police officer is in a place where he has a right to be talking to somebody who can say, I don't feel like talking to you anymore, trooper, but that didn't happen.
Could the defendant have said, get out of here, leave me alone, I don't want to talk to you?
Absolutely, he could have, and I think the trooper would have gone back to his cruiser. The defendant was not in a position where he was detained and prevented from doing anything. He could have walked away from the car, and the trooper wouldn't have had any ability to stop him from doing so, save any ordinances about.
I take it the trooper could have got out of his car with the dog.
He could have,
And
absolutely, he
walked right up,
could
and the
have.
dog sniffed the car, and just, well, okay, now I've got probable cause to a search. I mean, the trooper could have had the dog from the beginning.
Absolutely, he could have.
So if I understand this, your position is after the officer confirmed he had a valid driver's license and the car was registered, the guy could have just gone into his car, shut the windows, rolled the windows up, and just refused to engage with the officer.
Absolutely, there's nothing preventing that defendant from speaking with the defendant or with the trooper on the side of the road. The defendant didn't need to be outside of his car if he didn't want to be. There was nothing to prevent that defendant from walking away from the trooper, entering his car, and minding his own business and refusing to speak with the trooper. By the same token, there was nothing that prohibited the trooper from continuing to talk to the defendant because there was no type of interaction that went beyond, I would suggest, a common approach of an officer with a citizen on the street. So the fact that the trooper is speaking with the defendant after a license and registration check had been done, there was nothing impermissible about that contact with the defendant and the trooper.
Let me see if I have your position right.
Yes.
There's a car there and it's broken down. And your position is essentially that the trooper could have come up with the dog ab initio And had the dog sniffed the outside of the car, because we've said that a sniff is not a search.
I
As
think
long as
that-
there isn't too much of a delay.
I think that would be accurate.
That's your position.
If a dog sniff is not a search, then there's no requirement that the officer would have to justify the use of that dog. And if a dog sniff is not a search, I think absolutely the trooper could have had the dog with him and walk around the car.
And the question here is whether the driver was detained in some fashion, right?
I think that's part of it.
And
and
he
I-
was not detained.
That's the Commonwealth's position. I suggest that the motion judge got it wrong when he found that there was a detention, and that any further conversation after finding that the license and registration had checked out, I find that I suggest that there was an error with the trial judge's, with the motion judge's decision on that point. There was no detention because the trooper had done nothing to compel the defendant to stay at the scene.
I take it, Mr. Flego, that if we agree with you that there was no detention, and if we agree with you that the consent was voluntary, we don't even have to reach whether what could have happened in some other circumstance, correct?
I think that's correct.
That's
If-
an alternative, but don't you have a tough time here with the consent being voluntary because the trooper didn't tell the defendant that he had the right to refuse to consent, et cetera, et cetera?
I don't think so, Your Honor, and this court has never required that in order for consent to be knowing, that the defendant has to be advised you have the right to refuse. So I think that Judge Rufo's
But that
findings...
goes into the whole balance.
It does, but I think that the issue with Judge Rufo's findings on the consent issue is that it is solely based upon what he determined to be an unlawful detention, and that is mere acquiescence to the police. I suggest because we have no unlawful detention, because the trooper is there lawfully, Judge Rufo's analysis that I suggest hinges upon an unlawful detention is also erroneous.
Don't we examine the trooper's conduct or the officer's conduct under a reasonable and proportional sort of test?
Generally, yes, but not in this case. And the reason why I say not in this case is because we apply the rule of reasonableness to actions that the police do that violate or intrude onto some constitutionally protected zone. This court has ruled that a dog sniff does not intrude into a constitutionally protected zone. So therefore...
Wait a second. In the Feyenoord case, we held a canine sniff is not a search, correct? But the detention of a motorist for the purpose of summoning a canine unit, a dog, must be reasonable and proportional to the circumstances.
But in this case,
That
there was...
test doesn't seem to be met here.
But in this case, there was no detention of the defendant, and this is different from Feyenoord in that the canine was already on scene. This wasn't a radio call to find the nearest canine trooper to have the canine show up on scene. The canine was already there.
And the defendant was out of gas.
The defendant was out of gas.
Well, that's why I say it's somewhat different, but if you find that the consent was not voluntary, was improperly obtained, then you're down another path, which is to say, which is slightly more complicated, because if you find that the reason why the trooper brought out the canine was in response to the defendant saying yes, it's a somewhat more complicated factual situation. So it seems to me that if you can find there was no detention and the consent was voluntarily given.
Sure, and I think that would be one way to overrule the
You have
decision.
two alternative arguments. Isn't that how you're going? You have one, no detention, and the trooper could have walked up with the dog from the beginning, and so that's okay. In the alternative, no detention and a voluntary consent, or you don't even need no detention. You have the voluntary consent.
Yes, I would say
So there are
that.
two alternatives.
I would say that I think the Commonwealth's position and the way I would describe it is that there is no, that the trooper would not need a reasonable basis or probable cause, reasonable suspicion to deploy the dog based on the
Do you
Feyenoord
think this
case.
court would hold that a police trooper, even if they're coming to the side of the road, coming up with a dog, did not implicate detention?
Not under these facts.
No.
Your Honor.
I'm going with the alternative theory that you have adopted of Justice Cowan's, that when a police trooper gets out of a car with a police dog, that a reasonable citizen would not think that that's some form of detention?
Judge, I would suggest
You
that
don't have to reach that question, right?
Well, I don't think you need to, but to answer the court's question, is that I don't see how that would be any different from the police using some other means to enhance their ability to make observations, whether it's using
I
a bright
understand.
spotlight to look into a
Do you know the
vehicle.
history in this country of using canines?
I'm sorry, Your Honor?
Do you know the history in this country of using canines just on the street with people who are not accused of anything?
I'm familiar with some of it, Your Honor. It
Yeah,
predates
I would think it's, yeah.
my existence.
I think that might be a rough road to go down, and I think the trooper acted perfectly appropriately in not doing that. That's not what this trooper did, right? This trooper got out of the car on his own without his canine, walked over and engaged a motorist in conversation.
Yes.
And when somebody stopped at the side of the road, it seems to me that that's perfectly reasonable conduct for the state trooper to engage in.
Yes, and I think chatting with the defendant is perfectly reasonable conduct.
So for me, the case boils down to, after confirming that there was a lawful driver and a lawfully registered car, what do we expect our police to do? Can they just engage in conversation and snoop until they find something that they need to take action on, or does their responsibility end at the point of the confirmation of a legal driver and legal car?
Their inquiry would end if this were a motor vehicle stop based on, say, for instance, speeding or an out headlight. But this isn't that case. And since that's not this case, where the defendant was not compelled by the trooper to come to the roadside, there's no legal basis or requirement for the trooper to end any further conversation with the defendant. And I also would suggest to the court that we have to take into account also that it may not be reasonable to expect the trooper to get into his cruiser and leave when we have a disabled motor vehicle on a busy road where there was testimony
No, you
that
have,
there have been cars that...
Justice Glaney's suggestion, that the trooper gets back in the car. And
Yeah, and the guy gets back in his car and listens to the Red Sox game until whoever arrives. Does this case stand for the proposition that every time there's a disabled car, because of lack of gas or flat tire, whatever else it might be, the inquiring police officer can get a canine sniff?
I think the case would
If
stand for...
we go the way you want to go, the answer has got to be yes.
I think it would be as long as the motor vehicle had not been previously seized and the defendant previously detained. And there's some
So anybody that breaks down and presents proper, license, registration, I mean, if they don't have that, that's different, is subject to a canine sniff.
Yes, because it's not a search.
And so that means that the state trooper can say, listen, I'm sitting at the side of the road here, I don't have my canine with me. Come over. It's going to take this guy a while to get his girlfriend to come. Just bring your car over and just get out and start sniffing around.
Well, I think we may have an issue there, whereas the defendant's presence at the scene, because the police officer is requesting a canine, but if long as the officer does nothing to interfere with the defendant's ability to leave, the act of deploying a dog is not a search.
Don't you think most Americans would feel a little repelled by that idea?
Some of them may, Your Honor. I can't speak for every single American. But the court has said it's not a search, so the police can do something without justification if it doesn't impede on a protected area. So some people may be cat people and not like dogs. Other people may be dog people and like dogs, and that may not bother some people if there's a dog on the scene. But regardless, it's not an issue where
You
the
put
defendant...
police and dogs together, and most people don't like it.
Well, that's a policy issue. If there's no search, there's no search.
And that's the Commonwealth's
There's
position.
no detention, there's no detention.
Right.
The question of whether police should have drug-sniffing dogs in their back seats whenever they go patrolling seems to me to be a secondary issue.
And that may be an issue that would be promulgated by the state police in particular rules and regulations or how canines are deployed, but not under the basis of a motion to suppress under Article 14.
Thanks.
So
That was a well-timed argument, Mr. Flake.
The yellow light argument.
We haven't seen much of that this morning. Good morning, Mr. Keeley.
Good morning, Your Honors. David Keeley for the defendant, Pedro Mateo-German. Your Honors, today I'd like to present my argument to the court in the order that they appear in my brief, if I may, unless the court has other plans for me today.
We'll interrupt you when we need to, Mr.
Okay.
Keeley.
This is, we don't have any case on this kind of thing, do we?
I don't think
broken-down car or disabled car.
I think this case doesn't fit into any of the cases, particularly the dog sniff cases. But I'd like to begin, Your Honor, just by noting that this case began, and I don't think there's any dispute about it, this case began as a community caretaker case. In the trial court, the Commonwealth sought to make it into a probable cause type of a case, a more traditional search and seizure case or Article 14 case. We're here today under the community caretaker. It's returned strictly to a community caretaker case because the government no longer argues that there was reasonable suspicion or even probable cause for using the dog sniff in the case. So we return to community caretaker. And I say it's very, very clear that once a drug sniffing dog comes out of a car, that and the Commonwealth, by the way, has never justified the use of the canine under the community caretaker exception, and that is clearly the beginnings of an investigation. If it didn't happen before, it happened when the dog came out of the car. That takes this case, the police officer's conduct out of the community caretaker exception.
But the community
What is he doing with the dog?
In the record, he's traveling from point A to point B. I believe he had come on duty from his home at someplace up beyond.
So the dog's in the car when he sees this car run out of gasoline.
Yes, that's right.
And we've said that a sniff is not a search.
Right.
So why couldn't he have the dog do whatever he was doing?
Because he's functioning under the community caretaker exception. This is not a stop. I mean, it's not a stop. It's not a detention. There isn't really any argument here today, Your Honor, that whether this is detention or not. It's not a detention.
Aren't you
But it
sort
is
of-
an inquiry.
But aren't you sort of saying, no, it wasn't a stop clearly, and the initial communication and the looking at the license and registration was all within the community caretaking function?
Absolutely, Your Honor.
But as time went on, I mean, I think this is what the judge said, but wouldn't you agree that you've got to get to a place where it becomes sort of a detention? I mean, he's kind of trapped there, and the police hovering around, I mean, isn't...
It's not a detention as so defined under traditional search and
Right.
seizure cases.
What
And by
I
the-
call a circumstantial detention.
Yes.
or a de facto detention,
Ah,
because he's
that's
out of
better.
gas.
I like
And that's
that.
going to segue into the
Yes.
consent argument that hopefully I can make. So,
But he's not, he's stranded. He's not stranded as a result of any official
No.
order or any
Well, he had-
assertion of authority.
That's right.
This is really no different than a police officer going through a parking lot at a supermarket with a narcotic sniffing dog.
well, I think it is for one important reason, and perhaps others, that here we have a particularized, we have a target here. And if I suppose if there was an overriding community caretaker rationale, the state police could take a number of dogs and go through Gillette Stadium, for example, Your Honor. But here we have a police officer who's focused on an individual, and he's acting under community caretaker. Once he begins it's very clear, once he begins an investigation, and this is an investigation when the dog comes out of the car. I mean, I don't see any other way to look at that.
What's wrong with that?
Well, it takes it out of community caretaker.
Okay, forget the community caretaker.
But he has no reason to. There is no reason to do it.
But he doesn't
I mean,
need a
He
reason.
doesn't need a reason, isn't that the point?
He may not need an actual reason to investigate, but once he begins to investigate, it's no longer community caretaker. And this court's decision in Knowles
He may need
actually controls on this point.
He may need a certain level of probable cause. He may need a certain reason to detain, but he doesn't need any reason to investigate.
Oh, no, he doesn't. No, I would readily concede that. But once the investigation begins, community caretaker is gone.
Okay,
And that,
it's gone.
So now what is left? What is left?
He's still investigating. He's
Yes,
asking
but
questions.
yes, but one thing's lacking, Your Honor, and that is a reasonable suspicion.
And he can't detain him without a reasonable suspicion. It comes back to your first point. You said there's no detention here. I mean, once it's no longer community care, if it's community caretaking, he literally can detain him for community caretaking purposes without reasonable suspicion to believe that he's committed a crime.
Right.
So that's out of the picture. I agree. It's an investigation. Now he cannot detain the person without reasonable suspicion, but he's not detaining him. Isn't that the point?
Well, I'm not conceding for one moment that.
I thought you said there was no detention here.
That there's no
And it was a
detention.
de facto detention.
There's not a detention. I believe what I said is there's not a detention, as detention is traditionally understood under traditional Article 14 cases. But he's going to say no to this dog sniff. He's out of gas. He has no alternative. He has nowhere to go. He's
Well,
waiting.
That's a consent issue.
So
That's a consent issue, and that would relate only, I assume, to the allowing the dog to go inside the car and sniff, because there would be no consent even necessary to allow the dog to walk around the car. There's no search.
well, I don't believe that's accurate, because I believe this court in Fanoid itself established as an absolute minimum that you're going to need reasonable suspicion to put the dog out on the exterior of a car.
Reasonable suspicion to detain someone to wait for a dog. Reasonable suspicion to detain, make someone wait until a dog got there. Then that's what Feyenoord says.
What we said in Feyenoord
Well,
is we conclude that the exterior sniff of a properly stopped motor vehicle, right, by a dog trained is not a search.
Right.
And properly stopped.
But what
means-
this court left open in Fanoid, in footnote 7, was whether or not you can use a dog when you don't have anything. And the Commonwealth concedes, at least for the purpose of today's hearing, that there is nothing. There's just the police officer's untrammeled discretion to use the dog on a disabled motorist. There's really no other way to look at it.
He had a hunch. That's all he had.
He had a
'Cause
hunch,
went
which
to
the
some kind of course that says, watch out for these people with dark windows and air fresheners.
Yeah, all 0 plus 0 plus 0 plus 0 adds up to 0.
No, a hunch doesn't equal reasonable suspicion.
Right. So this isn't, the fact that there's no traditional detention isn't dispositive at all. It's hardly, it certainly, it doesn't even make any particular impact, at least in my mind, because we certainly have an inquiry once a drug-sniffing dog is out around the car. That's an inquiry. And it's, this is no different than an exit order. It has to be reasonable in the circumstances. And what's reasonable about using a dog in this case? There isn't really any argument for the government on that point. They're relying upon the fact there's no search, there's no seizure, there's no stop. Well, Article 14 covers many, many other situations when the police encounter a citizen going about his or her business.
Certainly we were not prepared in Feyenoord, as you say, to even consider whether a canine sniff of a vehicle stopped for a traffic violation would meet Article 14 standards. So we are one beyond what we didn't reach in footnote 7, correct?
Yes, and I'm asking this court actually to go two beyond, because I'm asking this court to hold that that in order to use a drug sniffing dog on the exterior of a stopped vehicle, that not only do you need reasonable suspicion of criminal contact, which I believe is a position that has been staked out by members of this court in the Feyenoord decision.
You like the dissent in Feyenoord?
It's probably one of the best road. If you look at my brief, it's absolutely a roadmap, Your Honor, and I'm certainly grateful for that. I'd like to make a few remarks about
Good thing
consent.
you got here before
if-
December 1st.
Well, I'd like to make a few remarks about consent, and would simply argue that there is no valid consent here.
Well, that's the sort of issue we defer to the judge on.
Well, exactly, I believe,
And
you
the
know,
judge looked at all this, and he says, look, the Commonwealth, it's your burden to show.
right.
It's a persuasion, burden of persuasion. He said, you haven't persuaded me, and that's the end of that.
So the facts are not clearly erroneous, and the judge's decision falls squarely within precedents of this court and the appeals court on the consent issue. I don't think there's, with all due respect to the Commonwealth, I don't think there's any serious issue with regard to consent here. Perhaps I shouldn't say that, but I think the important and the reason why we're
I'm
here
sorry,
today.
what, there's no serious issue that there was no consent?
I think it's clear that the judge's factual findings are not clearly erroneous, and that the judge's ruling with regard to consent falls squarely within Massachusetts precedents. That's all I'm saying.
Why is that? What caused what caused this consent not to be valid, other than that?
Well, and straight from the cases you're on, number one is that, and of course our position is somewhat contingent on the courts accepting the argument that putting the dog in the car was an illegal act. But assuming that,
Well, there's two consents. There's a consent, first of all, to allowing the dog to sniff the car. Do you mind if my dog sniffs the car?
the exterior, yes.
That's the
And then
first
there's a
consent.
second one.
Right.
The second one, hopefully this court won't even reach that issue or that question, because I don't think you can't get into the car until you go around the car. But the judge also found that he is stranded out there, and that the trial judge's finding with regard to him being effectively stranded is worthy of deference. So there's no error with regard to consent below, and I would ask the court to defer to the trial judge's findings on that point. I would like to make some remarks about Phaenoid and take questions if Your Honors have any. I think in order for the drug sniff of an exterior of a vehicle, in order for it to be proportionate with Article 14, that you need more than a reasonable suspicion of some
More than a reasonable
more than a reasonable suspicion of some undefined or vague nefarious criminal conduct. Are
you starting to ask us to reverse Phaenoid?
Not at all. Not at all, Your Honor.
Fits within
Not-
Phaenoid,
It fits,
does it
this
not?
case fits very well within Phaenoid. What has to happen, because Phaenoid didn't decide the question of whether a reasonable suspicion of criminal drug conduct was required in order to use a drug sniff. That is an open question. And we're asking the court to answer that question today by going a step beyond to ensure the proportionality of a decision to put a dog on the exterior of a car. In other words, if you're going to search for drugs, reasonably suspect their presence there. It's really, at least in my mind, that it's clear that Article 14 requires that standard. No, nothing less will do. Reasonable suspicion of just generalized misconduct, I don't think gives the citizens of this Commonwealth enough protection, because a car could be stopped with a headlight out, fine. The police officer goes up to the car, approaches the window, maybe there's some fairly obvious evidence of intoxication. If it's just reasonable suspicion, then the police could use the dog. So there would be discretion there. Sometimes
You would equate it to our law on search incident to arrest. It's got to be arrest for what the search has to be for what the arrest was for.
Pretty close. I'm not saying it's quite probable cause, but at least have the suspicion. It bears, maybe it doesn't bear saying, but a drug sniffing dog is out there to detect narcotics. And if you're going to take that step, you should reasonably suspect the presence of narcotics wherever that dog is working. In this context, in this type of a context, this is not it's not a bomb sniffing dog by any stretch of imagination, where it's strictly going to be community caretaking and there's an overriding need to find. And I think some of the cases, the Supreme Court dissent that I cite talks about cases where, of course, the police are going to be able to use specially trained dogs to ferret out weapons, bombs, terrorist activities, and those types of things. But we're dealing with people who are stranded along the side of the road. It's a far different situation. So if there are no further questions, I'd ask the court to affirm the order allowing the motion to suppress.
Thank you.
Thank you, Your Honor.